We'll now take up case number 21-1767, Cruz versus the State of Florida.
Good morning. May it please the court and counsel. My name is Rafael Rodriguez. I represent Mr. Cruz on this direct appeal from the imposition of the death penalty against Mr. Cruz. This is Mr. Cruz's second visit to this court. Last year, this court vacated his death sentence based on the fact that the circuit court included information in his sentencing order that pertained to testimony in the co-defendant's trial. This court followed precedent by saying that was improper and vacated the death sentence. On remand, the circuit court reconsidered the imposition of the death penalty.
And we did just remand for a resentencing before the trial court, not a new sentencing phase, correct?
That is correct. The court reevaluated the case in light of this court's decision, which also found that there was no competent or substantial evidence to support the jury's specific finding that Mr. Cruz was the triggerman. Based on that, the circuit court actually made a finding that Mr. Cruz was not the shooter, and that's reflected in his resentencing order. He had previously stated that both defendants were equally culpable and had stated in his original order that the only thing that distinguished the two defendants was the fact that Mr. Cruz was the shooter pursuant to the court's special finding. On remand, the circuit court doubled down on its findings that Mr. Cruz and Mr. Charles, the co-defendant, were in fact equally culpable. He said that they acted in concert, they had equal footing, they participated equally, culpability lies equally in their hands. Both defendants are equally culpable. These are findings of the circuit court that come to this court and should not be disturbed because there is competent and substantial evidence to support those findings. And in fact, the state does not make the argument that they're not equally culpable in their brief. The only difference between the two cases was now the fact that Mr. Cruz was no longer considered the triggerman. And that is the only difference in the reevaluation. The court failed to give an explanation in its resentencing order as to why it was giving disparate treatment to both defendants, even though he had found that both of them to be equally culpable.
Although from the judge's perspective, the variable that mattered was that sentencing Charles to death was not an option because of what the jury
That
had
is
found.
correct.
I mean, he could have thought Charles was equally deserving of the death penalty and just didn't have the legal authority to do that.
Well, the state never pursued that issue with the Charles jury because since they already had a
on the shooter, but they sought the death. Did they not seek the death? They sought the death penalty.
They sought the
Charles,
death penalty. That's correct.
Right.
But in effect, once the jury had made a special finding in Mr. Cruz's case originally, he was basically foreclosed from arguing anything other than the fact that he was the shooter because there was a jury finding.
But obviously, a reasonable person looking at the facts of this horrible crime could conclude that it doesn't matter who the shooter was, and that they both deserve the death penalty. And in the case, you know, the trial judge didn't have the authority to impose the death penalty on Charles. So the bottom line is, unless your whole case, I mean, it seems like it all rests on whether there's just sort of whether this relative culpability rule, whether that still stands, because the court saying that they're equally culpable doesn't really get you all the way that you need to go, because the implication of that could be that they both should have gotten the death penalty, not that neither should have.
Well, no, the point that I was trying to make is that that is a settled fact in this case. Now, whether or not this court applies the relative culpability analysis is what the state is asking this court no longer to do in view of the Lawrence decision. So we're taking it one step further and saying that is the reality before this court. These are equally culpable defendants because there's nothing distinguishes between them. And what
to the extent that it relates to the particular circumstances of this crime, I think that's what that is about, correct?
Right.
That doesn't take into account other aggravation and actually wouldn't take into account other mitigation either, right? You've got that as part of the analysis here. You've got what happened in the crime, and then you have circumstances related to aggravation and mitigation, which bear on the ultimate penalty that is to be imposed. Isn't that correct?
Well, insofar as aggravation, both of them were found to have the same aggravators.
Well, but there is this factor, and again, I don't know that this is legally dispositive, but it might have been what is part of what is going on in this case about the subsequent Hungry Howie's robbery and the findings of the court about the kind of the viciousness of the pistol whipping that the defendant here administered to one of the victims in that case. That is something that the court does dwell on. Isn't that correct?
It does. He makes that point, but remember that's an event in which both defendants participated, and that finding.
Well, but one person was doing the pistol whipping, right?
That's correct, Your Honor. But that was
the defendant in this case.
That is correct, but that was one aggravator that he was talking about, which is the prior conviction, which is applied to both defendants. And the circuit judge could easily, and this court has over the years reviewed circuit court opinions, could have easily laid out an issue as to why, for example, the mitigation in Mr. Charles's case may have verified or may have supported a life sentence, but no, he didn't do so. This court is deprived of that circuit court's reasoned judgment as to why he's treating these two defendants separately.
So can I ask you, I'm sorry, so let's assume that relative culpability went out the window with Lawrence. Is there any other legal principle that would warrant vacating this sentence just based on the fact that the jury that recommended death, a reasonable person could think that that recommendation was influenced heavily by the shooter finding, which we said was lacking in any evidentiary support?
So if I understand the court's question, it is whether or not there's any basis if you accept the fact that Lawrence did away with relative culpability?
Yes. So take that off the table. Is there any other legal basis?
Yeah, and we raised that in our brief, equal protection, which was not addressed in Lawrence.
Which has nothing to do with the shooter. Just forget about the other defendant and focus on the fact that the jury made a finding that had no evidentiary support according to our court, and that likely or plausibly influenced their death recommendation, which was obviously necessary in order for this person to get the death penalty.
Right, there is support for that, and that is that a jury's recommendation is not the end and be all of a judge's responsibility when he's considering the death penalty. This court has repeatedly said that the propriety of the death penalty is subject to the circuit court's reasoned judgment. And in this particular case, what we have is an indication by the circuit judge that the aggravators supported the jury's verdict, and that was the end of the discussion. He said, I'm not going to disturb the jury's verdict. But that is not the duty of the circuit judge at this point. The circuit judge, especially when he's viewing equally culpable defendants, is to demonstrate in his order why he's giving disparate treatment to these two defendants. We've raised the issue of equal protection because this court, as far back as Slater, nearly 50 years ago, said equal protection of the laws applies in this type of analysis. And it has done so in other cases which we set out in our brief. So in addition to that, we've also raised the due process clause of the state constitution, which this court can obviously interpret more broadly than any federal provision, because those are Florida state constitutional provisions that could be applied. We of course challenge the fact that Lawrence is determinative of this case, because Lawrence did not deal with relative culpability. It dealt exclusively with proportionality, and it relied on.
But haven't we overwhelmingly in our case law considered this the issue you're here on as kind of a subset of the proportionality issue?
This court has, on occasion, reviewed
well,
it.
But I mean, I understand you have some cases that you could argue we didn't. I understand that. But if you look at it as a whole, the body of case law where that has come up, isn't it a true statement that we have overwhelmingly treated it as a subset of our proportionality review?
You have, but this court has also 40 years ago said there are separate matters in the Palms versus Wainwright decision. And in that case, the defendant was trying to raise that issue, and the court says, no, no, no. These are separate and completely different issues that you're dealing with. So this court's opinions, yes, have used it, but there are other cases that have used them in different categories. And the point that I'm trying to make is that in the conformity clause, the jurisprudence of this court, it has been made very clear that in order for a Supreme Court case opinion to apply under the conformity clause, it must make clear and specifically hold a particular issue under that clause, under the, for example, cruel and unusual, or under the search and seizure procedures under Article 1, Section 12. That is not what happened in this case, because Pulley was simply involving comparative proportionality. Lawrence relied exclusively on Pulley, and Article 1, Section 17 requires a decision on the matter. The state has said, well, there's no decision that allows it to occur from the United States Supreme Court. But that turns the argument upside down, because the section of the Constitution, or Section 17, specifically refers to decision. To say to this court that the U.S. Supreme Court has never sanctioned it would be to basically handicap this court in its analysis of both search and seizure and cruel and unusual punishment, because we have to wait until the U.S. Supreme Court makes a decision specifically on an issue. That is not the intent of either one of those provisions.
When did you say Palms was decided?
Palms versus Wainwright.
When did you say
that? Was 1984.
I thought you said 4 years ago.
No.
I think he did.
No, it was 40 years ago, I meant.
40 years. Okay.
40 years ago, yeah.
I know time flies nowadays.
And I would also point out that the state's argument that you should apply Lawrence also disregards this long line of cases from this court, that this court does not intentionally intend to overrule decisions sub silentio. And that's also a line of cases that is before this court, because that is a doctrine that this court has applied. If we were to apply that doctrine, then Lawrence could not possibly have overruled relative culpability, because it was silent on the issue. There was no reference in Lawrence to relative culpability, zero. And in fact, it relied on the Jacob dissent. And the Jacob dissent, which was a single defendant case, didn't mention relative culpability. And it said very clearly that the Supreme Court decision makes clear, specifically holds that proportional comparative proportionality is not found, is not mandatory under the federal Constitution. But it said nothing about relative culpability. And this court has used that over and over again for the last 50 years. It even uses it in guidelines cases when there's differences between defendants. So it's not alien to the law of the state of Florida. And it makes sense that Lawrence would not have mentioned the McLeod footnote that was raised by the state in its brief, because it dealt with a completely different matter.
Wouldn't you agree, though, that as a matter of principle, the same things that make proportionality review kind of incoherent apply equally to relative culpability, in the sense of not being able to compare mitigation and aggravation and that sort of thing, that there are just too many variables to really have a principled way of even applying proportionality or relative culpability? I mean, they basically suffer from the same problems, don't they?
Well, there's two issues on that. One is comparative proportionality. This court never had any difficulty doing that. Absolutely none. For years and years, decades and decades.
I think that's probably in the eye of the beholder. But tell me why relative culpability in application is different from proportionality in terms of these issues that I asked about.
The main issue is you're looking at the same case. You're not looking at unrelated cases in the universe of cases. You're looking at the actors before the court, the actual individuals before the court. You're not looking at what happened in State versus Johnson and State versus Perez, you're not looking at that. You're looking at the case in front of you between the two defendants, the two actors in this case. And in fact, Edmond versus Tyson, which the state also relies on as the only feasible theory by which this court can assess co-defendants in a multi-defendant case, sanctions the looking of the relative roles of the defendants. The United States Supreme Court in Solomon versus Helm, cited in our brief, specifically talked about how Edmond talked about the differing culpabilities of the defendants. So it's not something that's completely alien to the law, and it is completely appropriate to deal with the actors in front of you. And in this case, this court is actually faced with a situation where the court has made a factual finding that they are equally culpable. He could have. Nothing prevents him from referring to mitigation as a difference, a distinction between the defendants, but he didn't do so. He did not do so. And this court should not be speculating.
But he does seem to focus on particular aggravation in this case. And even when he's coming down there to the bottom line conclusion, not just going through the individual aggravators, but on the conclusion about the imposition of the death sentence, he focuses to a significant extent on the video from the Hungry Howie's robbery, which he says that the jury saw the same and returned a verdict of death against Mr. Cruz. So there seems to be a lot of focus on that. Isn't that correct?
That is correct. That's what he wrote. But again, that refers to the one aggravator which applied to both defendants. Both defendants were found to have committed the same aggravator. So if that's the only aspect.
But we do know that the aggravators, that it's not inappropriate for a court to consider qualitative factors with respect to an aggravator. I mean, not every aggravator of this particular type would be equivalent. I mean, because the circumstances are different. It can be, so an aggravator can be more aggravated because of the particular conduct of the defendant associated with the aggravator. Isn't that correct?
That may be true, but...
Well, is it maybe true, or is it obviously true?
But because the only reason I say that is because the circuit judge said it didn't matter in this case who was the shooter or who was the one who inflicted the injuries. So who inflicted this injury at the Hungry Howie's shouldn't apply either, shouldn't matter to him either, but he said it did. And then on another aspect of his order...
I think he said the point about who was the shooter was, we don't know who the shooter was, okay? And so, and the idea that there can never be a death penalty in a case where you have two perpetrators and you don't know who the shooter is, we know that's not correct, don't we?
Well, we only know that when a court makes a specific finding in an order that this court can review. We can only know that. We cannot start speculating on what the circuit judge had in his mind. He had the ability. No one was standing over his shoulder saying, write this and write that.
I'm talking about the legal point that you need not establish, in a case where you've got two perpetrators, you need not establish who the shooter was for the death sentence to be imposed. Isn't that correct?
That is correct. But in this case, this court should not disregard the fact that this same judge in an earlier order found that to be the only salient difference between these two defendants. Then he did an about-face and said, well, it doesn't matter after all whether or not he was the shooter or who inflicted the injuries. So we're faced with an internal inconsistency within the same series of orders by this particular judge as to Mr. Cruz's the imposition of the death penalty against Mr. Cruz. All
right, counsel, you're down to 1 minute. You're only going to have 1 minute left for rebuttal. But so
okay, I will refer the 1 minute.
Thanks.
Good morning. May it please the court. My name is Patrick Bobek and I represent the state in this case. 2 years ago in Lawrence v. State, this court recognized the importance of a U.S. Supreme Court case, Pulley v. Harris, which found that comparative proportionality review in capital sentencing cases is constitutionally permitted but not required. Because of this state's conformity clause in its constitution requiring this court to review cruel and unusual punishment cases with U.S. Supreme Court precedent, it found that its comparative proportionality review violated that conformity clause. Relative culpability is, of course, proportionality review. I'd argue it's the quintessential form of proportionality review, because when you do proportionality review, you're attempting to find similar cases, and you can't get a more similar case than two co-defendants who committed the same crimes.
Wait a minute. Proportionality,
Yes.
it deals with whether the death penalty has been applied in similar type cases.
Right.
Okay. Now, relative culpability means that it could be whether the act, let's take hypothetically this case, where one defendant went in and did the killing while the other one was the lookout.
Right.
That's relative. That's why that deals. So they're two different things.
So I wouldn't, they're not two different things. Again, what you
We can
do.
go back and forth, but I can say they're two different things.
Okay. But I would argue your precedent doesn't agree with that. As Justice Kennedy pointed out in his concurring opinion in McLeod, which ended up being the basis for a lot of the reasoning in Lawrence, he said that relative culpability is an aspect of relative proportionality. And in Corman v. State, this court said in a majority opinion, in evaluating proportionality, one of the factors that can be considered is the disparate treatment of co-defendants. So that's this court saying it's a factor of proportionality review. And then when you look at this court's cases, when it's applied relative culpability, it's always in using it as proportionality. When you reduce a sentence from death to life, this court always does so because it was disproportionate to the co-defendants.
Can you explain why, under your logic,
Yes.
even aggravators and mitigators aren't suspect? I mean, aggravators and mitigators by their nature are comparators, right?
Yes.
You're comparing a baseline case, a hypothetical baseline case, and saying there's an aggravator or a mitigating factor. If we accept your rule that comparisons among defendants are suspect because of Lawrence, what saves aggravators and mitigators?
Well, I'd argue because they are inherently subjective. The weighing process is inherently subjective. That's why we have the jury do it. That's why we have a judge review their findings and lay out the weight he gives to each of them. So they're not suspect. They're just, it's an inherently subjective process that the jury and the judge has to go through when they weigh those. And the Supreme Court has actually given us guidance on what to do with co-defendant cases. That's the Inman-Tyson test. All that, and the focus is always on the individual, which is in line with Supreme Court precedent saying you should have individualized sentencing in death penalty cases. And you should look at not just the conduct of the defendants, but their background, their unique characteristics, and everything about them. And the Inman-Tyson test just says the person must be a major participant in the crime and act with at least reckless indifference to human life. And this court has already found that Cruz meets that test. And since that's the only thing this court needs to apply in co-defendant cases, and it already has been found to exist, Cruz's death sentence should stand.
Could you talk to us about this particular case in this particular order, in the sense that it doesn't inspire a lot of confidence? I mean, you know, you've got a jury that makes a finding that's a critical finding that this court decided was lacking in evidentiary support. You have your initial order that your colleague focused on, the sentencing order. Then we have the do-over sentencing order that doesn't seem like it really attempted to kind of re-justify the imposition or re-explain the imposition of the death penalty in light of the shooter thing not being on the table anymore. You had a judge who repeatedly concluded that mitigators weren't proven, but then still assigned them weight. I mean, I don't know that legally what this court should or can do about that, but I'm curious to hear your perspective on sort of this particular order and, you know, how it's sort of legally justified.
Of course, and I think it's important to note that the first sentencing order came out in 2019 when this court still did a comparative proportionality review. And so that's why there was a focus on the jury finding that Cruz was the shooter, because the judge had to justify with relative culpability and proportionality review why Cruz was more culpable and why he could impose the death sentence. In this new sentencing order, it's post-Lawrence. He doesn't have to do proportionality review. He therefore doesn't have to do a relative culpability review. And so he just has to look at the aggravation and decide, does he agree with the jury that it outweighs the mitigation? And he exhaustively went through each aggravator, each mitigator, weighed them against each other, and agreed with the jury that aggravation outweighed mitigation. So the timing of the orders, I think, is important and explains what looks like a contradiction between the first and second.
Do you think, though, that, does it raise any red flags for you, though, when you read an order that seems to be so interested in sort of trying to justify a jury decision or to be appropriately deferential to that, when we now know that the jury's recommendation could very well have been infected by, a major error?
I think, if anything, he was more deferential to the defendant. Like you said, he would explain how he thought a mitigator didn't necessarily apply, but then find that it was proven. For example, that Cruz was a minor participant in a crime committed with someone else. He gave that moderate weight, but found that Cruz, under no circumstances, was a minor participant. And I think he gave it moderate weight because he was focusing on the fact that another participant was in the crime, which is part of the mitigator. I think that's why he found it as found. I think that's why he gave it moderate weight. So I don't think he was deferential to the jury's finding. I think he just agreed. I mean, this is a highly aggravated case. 5 aggravators, some mitigation, but not nearly enough to overcome some of the weightiest aggravators in this court's precedents. And so the death sentence was justified in this case. If there are no other questions, right, I just would ask that this court uphold the convictions and sentence of death. Thank you.
Very briefly, the second order did talk about proportionality even after Lawrence, so there's no timing issue here.
I think he was using that as a synonym for the weighing process, the weighing of the aggravators as opposed to the mitigators. If you look at it in context, wouldn't you think that's what he was talking about?
Well, he cited a
because he
case.
wasn't really talking about other cases. He's talking about he's weighing the aggravators and mitigators.
I think he cited one case in that portion of the order, but in any event, again, we would argue that Edmund Tyson only applies to those threshold of cases below which a state cannot seek the death penalty. It doesn't talk about relative culpability, and it doesn't bind this court not to apply relative culpability. We conclude by asking this court to consider the following. The state's argument is asking this court to stroll into a legal minefield, to disregard this line of cases of sub silentio, to disregard its jurisprudence and the interpretation of the conformity clause, and to throw out relative culpability that has been applied in this court for over nearly 50 years. It asks for a radical reordering of this court's precedent. We ask that this court vacate the death penalty and request that the circuit court enter an order of life. Thank you.
Thank you. The court's adjourned.
All rise.